Well, the apex court making its view quite clear that it will have a hands-off approach with respect to the ongoing elections and not directing the election commission, not granting that interim relief of directing the election commission to release individual polling data, that's voter turnout data for individual polling stations. That's the big takeaway. Now, why did the apex court come to this assessment? How did it come to this view? We'll try to answer that question. Now, what's important is that the apex court was hearing a couple of applications, one filed by the Association for Democratic Reforms and one filed by TMC MP Mahua Moitra. The question that was raised before the apex court is that there has been divergence in terms of the voter turnout data that has been revealed by the Election Commission on its applications and the later revisions that have been issued by, again, the same Election Commission, and that in light of that, there is a need felt by the petitioners to disclose voter turnout data for individual polling stations that's recorded as a part of Form 17C, and that this information needs to be made public within 48 hours. Now, this is contended by the Election Commission, challenged by the Election Commission. They filed a very lengthy affidavit, but what's interesting is that even before going into the merits of the case, the Election Commission challenged the maintainability of the petitions, the maintainability of the petitioners in question. Now, again, just to remind our viewers, there are two petitioners here, Association for Democratic Reforms and Mahua Moitra. Maninder Singh, senior advocate appearing for the Election Commission, essentially argued that both these petitioners have a history of filing applications that seek to cause chaos and confusion with respect to the electoral process, that both these petitioners seek to build public distrust as far as the election exercise is concerned. To that end, Maninder Singh also cited previous applications that have been filed by them, and that's specifically cases involving the electoral rolls, also cases involving the integrity of the EVMs, and saying here that both these petitions that have been filed before the apex court are stemming from a sense of suspicion and apprehension and should not be permitted by the apex court, should be done away with, and a strong message needs to go out from the apex court. Now, in addition to these submissions, the Supreme Court made some very pointed questions and aimed it at the petitioners. Number one, the question that was asked is, why is it that petitions that were filed in 2019, both these applications were filed in 2019, why is it that they were being pressed in 2024? Why a 5-year delay? Another technical question that was raised by the apex court is that the interim reliefs that have been sought in both these petitions is the same as the final relief. Here the apex court said, essentially observed, that if this interim relief is granted, it would also mean grant of final relief, and there would be no question of needing to hear this application any further, and that is a technical ground that in fact was confronted, the petitioners were confronted with. Third, the apex court also took note of the fact that the Election Commission, of its own volition, on a voluntary basis, on a non-statutory basis, already releases voter turnout data on its application. Sure, the apex court observed it's not entirely accurate. Sure, there might be certain divergences, that it is only tentative in nature, but it does give a broad picture as to the way things are headed, and that is something that needs to be borne in mind, something that needs to be welcomed, and that there needs to be some trust that needs to be reposed in the Election Commission. In fact, at one point, Justice Dipankar Datta even observed that releasing this data on a voluntary basis would be an "Aap bail mujhe maar" approach, given that even despite this initiative, the Election Commission was being criticized. So on the back of that, the apex court making its view quite clear that it will not intervene at this stage. It will have a hands-off approach. There are 7 phases of the elections. 5 are already done. Only 2 are left, and therefore no grounds have been made out for grant of interim relief. This application will now be taken up in due course, which will be after the summer break of the apex court.